Hello, beautiful people. Good afternoon to you. We're live across all our social media platforms that allow liveability. So we're live on Facebook, Instagram, TikTok, YouTube. I think that's about it. Join in. We'll be sharing our screens from Facebook, YouTube, and LinkedIn. So if you want to see what we're seeing, you can join on those platforms. And once you join, if you can see me really clearly and hear me very well, please drop USA in the chat box. Drop USA in the comment section. We're going to get started very soon. We have a lot of interesting, exciting things to discuss with all of you. So join in, drop your USA. Okay. So we have somebody says they traveled on their 2-year green card and had no issue coming back. Kalashnikov 47 on Instagram. Thank you for sharing. There's a lot of questions I see already coming in. We'll be answering your questions very soon. Please make sure you're dropping USA. If you can hear me good, you type USA, drop the emoji of the US flag. And then we can get started. Guys, I'm so sorry. Last week we couldn't come live. I was out of the country, but we're back today. I apologize for the absence. So today we have a lot to cover. So let's jump right into it. Alrighty. We're going to be starting with the latest policy on naturalization. The latest policy on naturalization. If you want to become a US citizen as a foreign born national, the process you go through. There are generally about 4 main ways a person can become a US citizen. The first one is by the principle of jus soli, automatic acquisition. If you're born on US soil, then you are a US citizen by birth. Obviously, there are some people who are exempt or fall within the exception to this rule, like children who are born to diplomats. We've shared this several times here, so you know that children born to diplomats in the US, they can register or create a record for lawful permanent residency to get green cards. They are the exceptions. If you're not subject to the jurisdiction of the US, even if you're born in the US, you're not a US soil. But first group of people who, or first way to acquire US citizenship is through automatic acquisition if you're born on US soil in the United States and your parents are subject to US jurisdiction. The second way is through either automatic acquisition. Well, the first one is automatic acquisition, right? Based on the fact that you are born on US soil. The second one is automatic acquisition at birth. At birth means you have a parent, for example, who's a US citizen, or a mother or a father who's a US citizen. They were US citizens before you were born, and sometimes they have to satisfy certain physical presence requirements, among other things. That's automatic acquisition at birth. Then we have the third one through the principle of derivation. People can become US citizens through the process of derivation. If you guys can hear me, please drop USA. I feel like my voice is going out and in. Please confirm that you can hear me well. Third method of acquiring US citizenship is through the process of derivation. This is when you become a US citizen after you are born. So you acquire, you were born, let's say, outside the United States, you acquire lawful permanent resident status. And can you guys hear me on Instagram? There was a call that was just coming in. Let's make sure you guys can hear me well. Please keep dropping the US flag. If I hit a note you are enjoying, just drop the US flag as, just a way to communicate. Okay. So the third method is derivation. A person who's born outside the US, for example, they can acquire US citizenship after birth, and usually even before they turn 18 years, if their parents have also met certain physical presence requirements, and there are other criteria that the parents who are US citizens have met. So usually parents, for example, can naturalize themselves, or they can become US citizens. Then so let's say father was a US, or father was a foreign born person. He was born in Tokyo or Ghana or Nigeria. He was not a US citizen. And then he gave birth to a son. His son was also born in, let's say, Ghana or Nigeria. Son is not a US citizen. By the time the child turns 5 years old, father is living in the US, has gotten a green card, has become a naturalized US citizen, and the father can then petition for this child through the principle of derivation. In that case, the child will acquire lawful permanent residency or a green card or immigrant visa once they come into the US, and they are in the physical and legal custody of their US citizen parent. Then the child will be said to have derived US citizenship. Certain requirements must be met. And the fourth method is through the principle of naturalization. You're foreign born, you come into the US, you meet 9 legal requirements, including the fact that you obtained lawful permanent resident status properly. You're a lawful permanent resident for some time, sometimes 3 years or 5 years. For some people, it can be shorter if you join the military, for example. Those people, then you become a green card holder. Then you apply after you turn 18 years to USCIS and say, you know what, I'm ready to go through the vetting, screening, and process to become a naturalized US citizen. With that one, it's after again you turn 18 and then you can become a US citizen. Okay, so now USCIS has updated the rules. If you are applying for naturalization, there is a component that they have to analyze. They've updated that component. This is really important, and let's stick with me. There's some legal revelations I'm going to be making in this live video session. Again, you will not hear this anywhere, so stick with me. Let's discuss this, and I'll share with you and what this means for you, what you should look out for moving forward, so we can understand what these policy changes are and how they impact us as immigrants in the United States. All right. So the policy, I hope you guys can see. Am I already sharing the screen? Okay, yeah. So the policy is in a policy memorandum that USCIS released on August 15, 2025. It's entitled Restoring a Rigorous, Holistic, and Comprehensive Good Moral Character Evaluation Standard for Aliens Applying for Naturalization. If you're applying for naturalization, meaning you are a green card holder, lawful permanent resident, and you are above 18 and you want to go through the process of becoming a US citizen, you have to make sure that you qualify as a person of good moral character. That's one of the 9 fundamental eligibility criteria to become a naturalized US citizen. There's a bunch of them. We won't go through that. That's not the purpose of this video. Now, one thing you must establish is that you are a person of good moral character. And so the officer has to evaluate whether you are a person of good moral character. Before August 15, 2025, what officers did was just simply use a checklist and say, okay, do you have any disqualifying acts? And for US or naturalization, US citizenship or naturalization, one of the things that they're looking out for is that you don't have a permanent bar to good moral character, right? So think about it this way. In order to rise up to be eligible to be a naturalized US citizen, you have to go through some hoops. The first one is that you have to be a person of good moral character. Good moral character, if you have something called a permanent bar, you cannot establish good moral character, and therefore you cannot become a US citizen. Permanent bars include things like murder, aggravated felonies. There are a bunch of things that encompass what an aggravated felony is. Certain types of fraud offenses above a certain amount of money, above $10,000, some sexual offenses. It's quite detailed. We won't go into that today, but those things will permanently, forever bar you from ever establishing that you're a person of good moral character. If you've killed somebody, then no matter what happens, they will never believe that you're a person of good moral character. It doesn't matter that you go on to repent, to become saved, or you just change. You just cannot establish it. Number two, something called conditional bar. With conditional bar, if you commit certain types of crime within your statutory period, either within 3 years of eligibility or the 5-year eligibility you are using, then you cannot establish good moral character within 3 years before your application or within 5 years before your application. So if, for example, you are a habitual drunkard and you've been a drunkard since 2024, you cannot apply for the US citizenship in 2025 and establish that you're a person of good moral character. It will be denied because you don't meet good moral character, and you are conditionally barred, because if you are applying based on the fact that your spouse is a US citizen, then within the period of 3 years before the application, you should not be a habitual drunkard. Now, if you were a habitual drunkard in 2002 and it's 2025 and you're applying on the basis of being a permanent resident for 5 years, so they look at the statutory period between 2020 and 2025, then you are safe. Because it's just a conditional bar, you are generally safe, right? But now the rule from August 15th is that they are no longer going to look at these checklists and say, oh, you haven't done this, you haven't done this, you haven't done this. And for that reason, you are presumed to have good moral character. No, moving forward, what it's going to be is that they have to look at the officer who's reviewing your naturalization application. He has to do a holistic analysis, a holistic assessment. He's going to look at everything, not just the fact that, oh, because you have not done. Guys, it looks like my ring light is off. Okay. Oh my gosh. Okay, there we go. Where the officer has not, my goodness, my lights were all off. I'm sorry, guys. So where the officer has not, the officer is not just going to look at, you don't have these disqualifying factors. Now he's going to do a whole assessment. And if you look on the screen I'm sharing, it says that evaluating aliens or non-citizens or foreigners who are seeking to become naturalized is the most sacred and profound responsibility that USCIS is charged with performing. If you want to become a naturalized citizen, they're saying that it means being an active and responsible member of your society, instead of just having a right to live and work in the United States, right? And among other eligibility factors, you have to continue, you have been and you continue to be a person of good moral character. So now there's not just going to be a cursory mechanical review based on the absence of wrongdoing. So the fact that you haven't committed crimes is not going to mean you are eligible for citizenship. You have to actively show your positive contributions that will demonstrate that you're a person of good moral character. Now let's move on. Let's look at the post. Oh, hold on. No, let's go back here. Let's go back here. Let's look at pre-1990. I'm sorry, pre-1990. I'm not sure why am I here. Okay, now pre-1990, there was a discretionary framework. Before 1990, and I'm going to tell you guys, remember that we did a live video, I believe a couple of months ago, where we looked at discretionary analysis when USCIS is reviewing your case. There seems to be some discrepancy here, because if you remember, when USCIS is reviewing a naturalization case, there should not be a discretionary analysis in that review. For naturalization, so long as you meet the eligibility requirements, you should be approved for citizenship. But now Look at this. They seem to be introducing a discretionary review in citizenship. And that obviously it's not for the whole naturalization process, but just for the good moral character part, which forms a fundamental part of the naturalization review. So look at the pre-1990 discretionary framework. Before the early 1990s, INS officers determined good moral character. What they did was that they treated the the bars or the or the negative conduct or criminal conduct in law as the minimum disqualifiers. Okay, they treated that as the minimum disqualifiers, and once you had no bars, it did not mean they'll stop there. It was just the bare minimum. They would go on to now evaluate other things, right? They would look at your positive contributions, volunteer service, your family, relationships or responsibilities, things like that. That was pre 1990. Now, after 1990, they now moved towards a checklist approach. They would move on to see, okay, you don't have a drug offense, check. You don't have fraud on your record, check. You do not have misrepresentation, check. And therefore, because there was an absence of these negative disqualifications or these disqualifying features, then you were presumed to be a person of good moral character and they would approve you. This has been the framework since that time. The standard, as I mentioned, is by preponderance of the evidence, meaning it is more likely than not that you are a person of good moral character so long as you don't have any negative criminal history or bad things that you've done in the past. Okay. Now, if you guys see, we shared it on our social media. Matthew is a Tragasa. He's one of the the spokesman for USCIS, and he said that U.S. citizenship is the gold standard of citizenship around the world, and only the world's best of the best should be granted U.S. citizenship. This is really in line with what Trump has been saying and his entire administration has been saying. They want only a certain type of people to be here in the US, a certain type of people to be granted US citizenship, the creme de la creme of the world to be granted US citizenship. So that is why they seem to be trying to increase the burden on applicants, because they know that if they have to change the legal standard, they cannot do so through a policy memorandum. They are doing this, which effectively increases the very heavy burden on immigrants. That now immigrants have to show more in order to show that they are eligible for naturalization. They have to prove so much more. Okay, now let's come here. Let's go to the 3 areas: totality of the circumstances approach. Here, the first thing they're looking out for is that you must have positive attributes or contributions. They're going to be looking at whether you have, positive contributions. Again, they've given a bunch of examples as to what the law is looking out for, what the officer that will be interviewing you during your naturalization case, what they're going to be reviewing during that moment. They are going to be looking at a whole lot of things, including your educational attainment. Okay, they're going to be looking at your, let me go back again. Well, let's start with the first one. They're going to be looking at your sustained community involvement and contributions in the United States. What does it mean? Community involvement during COVID-19 pandemic, for example. What were you doing? Even beyond the COVID-19 pandemic, there are some people that went at the forefront of this pandemic. They were nurses, they are nurses, helping the society. And again, beyond the COVID-19 pandemic, even now, some people live really honorable lives. Some people, are teachers. They teach special needs children. They work in the church. They even work in Walmart or work at Home Depot. They've worked at Home Depot for 15 years. They are really involved in volunteer drives. They donate, they help, schools. They volunteer within their communities. They're just good, upright members. Um, in their homeowners association, they can volunteer in their neighborhoods. They are great people. They are very serviceable. They bake cookies for their neighbors. They are looking at these things, your sustained community involvement. How involved are you in the community and your contributions in the United States? So if you're somebody who's brought great contributions, you've come up with something that you're doing perhaps in your community that has brought an advancement, maybe some type of book drive initiative for the children in your neighborhood. Again, it doesn't have to be something so fantastic or in the sky. It can um, it can just be things that you are doing to help in initiatives or just helping in your own little way. Okay, helping in your own little way. And you have to document all these things. Make sure you have documentary proofs of things you've done. And now we're going to be having to document the things we're doing within our local communities. Are you helping with, food banks, for example? If they are feeding homeless people, shelters. Are you volunteering? Are you helping local organizations at events, orphanages? Are you spending your time just doing good things, participating in neighborhood programs, engaging in public service, just showing through your actions that you are somebody who contributes in your community? This can be a little difficult to predetermine, but look within your own community and see how you can be, get involved, be active, serve, and make sure you have evidence of that as well. Okay. Now, the second thing is family caregiving, responsibility, and ties in the United States. This one is easier to prove for many people. For many people, you want to make sure that if you're a parent, you are a responsible father. You're paying your child support. You live with your family, for instance. You don't beat your wife. You don't slap her. You cannot be slapping your wife and expect to get naturalization. That's domestic violence. If you have such a charge, you become deportable. Okay. As you have such a conviction, you become deportable and you can be sent to immigration court. So you want to make sure that your family caregiver, you are just a good present father, a good present mother. Responsibility, your ties in the US means how rooted are you? How long have you lived here, for instance? Do you have properties? Do you have children? Do you have family? Do you have businesses? Do you have projects you are doing in the United States? How tied are you to the community such that you want to establish your ties or make sure your ties go in even deeper? When we talk about educational attainment, how far gone? You have what, 2 PhDs, 3 master's degree, but again, it doesn't have to be that fantastic. Just how much have you achieved in your educational life? Obviously they want people who have studied, people who are advanced educational, they're just advanced academically, I should say. And even if you are not necessarily lettered, right? You're not necessarily lettered. Even taking courses or taking some skills courses to advance yourself, English as a second language, adult education, all those type of things. You have evidence of it. That would be great to package and then show that you have this. And as I always say, you guys, when there is a new policy, it's not, we do, the new policy is just a starting point, right? The new policy is always just a starting point. It's the written policy memorandum is a starting point of what immigration is going to be looking out for. Now, the actual application and how this policy will be applied in real life circumstances is what will develop over time. Okay. So when a policy is issued, the full impact may not be clear right away. It will take time for USCIS or the agency to apply that policy to cases, and courts can sometimes weigh in by deciding on actual cases that come into court. It's through that process that we'll see how the policy is actually being interpreted, and how much discretion, and how officers will exercise their discretion, and whether an agency's reading of their policy will withstand judicial review. Will it be struck down? Will it be upheld? Will it evolve? Will it be modified? Okay, so the text of the policy memorandum is only the starting point. The meaning of the policy will develop over time through implementation of the policy by adjudicators and interpretation by the court system. Okay. All right. Now let's go on to the third thing, stable and lawful employment history and achievements. You want to make sure you don't just job hop, right? You don't just job hop. Stability and even the way you carry out your responsibility as a working person. You've been with a company for 8 years, 10 years. That's some stability. You've been with a company or an organization for 15 years, you moved on to another one, you've been there for 8 years. Those are very good things. It shows you have stable, lawful employment history. If you are job hopping every 3 months, every 3 months, every 6 months, they don't like that. It's not a positive attribute, or it's not a positive attribute for you. Then length of your lawful residence in the US. How long have you stayed in the US? Obviously, the greater the better. If you lived here for longer, that is a positive attribute for you. Compliance with tax obligations and financial responsibility. You got to make sure you're paying your taxes, county taxes, state taxes, federal taxes, property taxes, car taxes, right? Obviously, property encompasses both car and immovable property as well. So there's going to have to be a submission of these types of evidence, even for your naturalization case, right? Because your attorney would have to review what what your attributes are, and then present them in a positive light for your naturalization application. So you're going to have to find evidence of these type of things, documentary evidence. Remember, these things, in the positive factors include, but are not limited to, these things I've mentioned. And so whatever you have to show your positive contributions to the United States, there will be greater emphasis that's placed on this by the adjudication officer. Now, the next thing is that there's going to be greater scrutiny on your disqualifying features, disqualifying behavior and action. Disqualifying behavior and action. Let me go here. Let's go. Let's come here. Okay. Let me see if, hold on, guys. Let's see here. Okay, let's move on to the second thing. There you go. Okay, I found the screen right here. Greater scrutiny of disqualifying behavior and action. So USCIS is going to focus attention on whether you engage in any behavior that disqualifies you. So they're looking at permanent bars. We already mentioned, forever you are barred from ever becoming a US citizen. Crimes of violence, murder, aggravated felony, genocide, torture, severe violations of religious freedom, conditional bars, such as false claims to US citizenship, unlawful voter registration, unlawful voting. Remember that some of these things also make you deportable, and some could make you, we're looking at, in this instance, we're looking at green card holders. So I will not even talk about inadmissibility. These, if you're a green card holder or lawful permanent resident, and you are convicted of some of these things like controlled substance violation, you become deportable, and that means you can be sent to immigration court for deportation proceedings to be held against you, and your naturalization case will also be denied for lack of good moral character. I'm sorry. All right. So the next thing is that any other acts that are contrary to the average behavior of citizens in the jurisdiction. Here, I find that the wording wasn't very clear in the memo. It said that these actions, so it said the third point is that any other acts that are contrary to the average behavior of citizens in the jurisdiction where the alien resides. These could be actions that, while technically lawful, they may be inconsistent with civic responsibility within the community, such as reckless or habitual traffic infractions or harassment or aggressive solicitation. I find that it wasn't worded really well, because if you say that these actions, while technically lawful, habitual traffic infractions can never be technically lawful. So perhaps what they wanted to say was that even though some of these things may not technically be criminal in and of itself or crimes, all right? If a traffic infraction, maybe you cross a red light, or you are speeding above what the average allows you to go, then they may not technically be crimes, but they could count against you if it's often repeated, like that. These are things that happen regularly. Harassment or aggressive solicitation. You guys know what that means. Aggressive solicitation, just chasing people, persistent begging, like just aggressively trying to get them to perhaps buy your services or buy your goods, just these type of things. Then the third is that fourth, when they're assessing acts that are unlawful or contrary to the average behavior of citizens of the community in which they reside, they'll review all available documentation and they'll question the alien. So there's going to be two ways in which they evaluate this. Number one, documentary evidence, and number two, oral testimony. These are two ways they will elucidate or they will review whether you qualify or you meet the good moral character for naturalization. So your documentation and your oral testimony, these are things that have to be prepared really well to show that you are eligible or not. Now, third thing they'll review is rehabilitation and reformation. The government even understands that everybody makes mistakes. Everybody. There's nobody that doesn't make mistakes. People make mistakes. People learn. People grow. We make mistakes in our daily lives. And so if there's somebody that has engaged in wrongdoing in the past and they are properly rehabilitated and reformed, then they will look at that rehabilitation consistent with the totality of the circumstances approach. They want to see evidence that you've truly changed. It's not just word of, mouth service, like, oh, I've changed. What is the evidence that you've truly changed? If you are somebody that doesn't pay child support, or you're somebody that has committed adultery, that has destroyed a marriage. I'm not saying it. The law says it's a conditional bar to citizenship. Unless you can prove extenuating circumstances, right? So if you are able to rectify overdue child support payment, so you owed child support, maybe you haven't given your ex-wife or your baby mama, you're supposed to be paying child support $600 every month for one child. And 3 years you haven't paid it. If you pay it, and then maybe you owe alimony, maybe your ex-wife, you're supposed to pay her $2,000 every month, and you rectify that family obligation, it's a good sign that you have rehabilitated. The second thing is your compliance with probation or other conditions imposed by a court. When you go to sometimes criminal court, they'll place you on some type of probation. You follow what the judge is ordering you to do. Third, community testimony from credible sources, which attests to your ongoing good moral character. So affidavits of support from your church pastor, your community leader, your boss, your work colleagues who are credible, people your neighbors, your child's headmaster. They've seen what you do, how you volunteer, how you help. Your neighborhood hospital, they can attest to the fact that you're a good person. They can write all these things for you. Reformation or mentoring those with similar past. So if you've reformed from drinking, and you go and join Alcoholics Anonymous, and you are able to provide therapy for other people who are addicted to drinking, that's a good thing. Make sure you document these things. Full repayment of overpayment of benefits as SSI. If the government has paid you anything, Social Security, I believe SSI is Social Security insurance. Let me just verify that really quickly. If you repay, you don't say that, oh, they were supposed to have paid me $2,000. The government paid me $5,000. I'm pocketing all the money. If you do that, then you're not showing that you are, yes, supplemental security income. Okay, that's it's by the Social Security Administration. And it is that monthly payment to people with disabilities who have little or no income or resources. So if you are on these payments and they were supposed to pay you maybe $600 a month and they paid you mistakenly $1,500, you have to go and repay it to show that you're a person of good moral character, as part of the rehabilitation ground. Then the last one is full payment of overdue taxes. Okay, so these are things where you have to make sure you have both documentary evidence and your oral testimony. You got to make sure you document all these things really clearly. That's how they're going to be adjudicating good moral character. Let's move on to our next topic for the day. We have a lot for today. We have to discuss. We have to discuss CSPA, child status protection. I don't know if we'll have time to discuss that false claim to US citizenship. We have to discuss a whole lot of other things because last week we were not able to come. Okay, let me take this off. Now let me see what is the next thing we can move on to. I think we can move on to no, not this one. This is the anti-Semitic one. Let's see here. Let me take this off. Guys, drop your questions, drop your emojis, US flag. If you don't have any comments, you're just enjoying the session, just drop it. And then I can see that it's going down well and you guys are hearing me and following what we're discussing here. I think we should do the CSPA. Let's do the CSPA. Let's do CSPA here. Where's my CSPA? Okay, there you go. Let's talk about CSPA because I see a lot of comments. Well, one person sending a lot of comments about the CSPA, and I actually plan to also discuss that as well. So let's get started with that. Okay. All right, you guys can see my screen well. Excuse me. So CSPA is Child Status Protection Act, the Child Status Protection Act. And CSPA does not apply to everybody. Okay, we're going to, I'm going to explain very, very well what CSPA is. So pay attention. It can be a little complex if you don't understand it, but it's very straightforward as well. Okay. So CSPA, as I mentioned, is Child Status Protection Act, right? Now, it only applies to some groups of people, okay? It applies to people who are called derivatives, or it applies to people who are in the preference immigrant category, okay? Now, CSPA, because immigration processing takes such a long time, CSPA is supposed to help with people or prevent people from aging out. So if somebody is supposed to immigrate to the United States as a child or get a green card as a child, then CSPA will freeze their age and allow them to immigrate as a child, okay? Because immigration, the way it's organized is such that for you to get a benefit, it depends on who is filing for you. Number one, who's filing for you. Number two, what their relationship is to you. And number three, what your age is. So if you are under 21 years old in some categories, your cases get processed really fast. Okay, so CSPA is supposed to make sure that even if immigration takes 5 years in processing, if you were 17 years old and immigration took 5 years, so by the time immigration is processing your green card, you are 22 years old. You should no longer be processed as a child. CSPA is supposed to freeze your age to make sure that you don't age out or turn 21 based on immigration's own delays, USCIS's own delays, or the government's own delay. So CSPA creates a legal fiction, and it will allow a person who should not be processed as a child based on their true biological or chronological age. They can continue to immigrate as a child based on their CSPA age on their statutory age. Okay. So, for example, if you are a child of a green card holder, an LPR, or you are another derivative child, let's say you are under F2A as a minor child of a US citizen, as a minor child of a green card holder, let's say you're about 18, well, yeah, let's say you're about maybe 17 years old, and your mom filed for you as a minor child of a green card holder. Once your application is being processed, CSPA will come in to say that, okay, let's freeze this person's age by looking at his age on the date of visa availability. What was this person's biological age on the date of visa availability? And then let's take out how long the application was pending from his age on the date of visa availability. And that's what will give you your CSPA age. And so maybe I'm jumping ahead of myself. Let's follow this. Now, CSPA will preserve someone's ability to immigrate or get a green card as a child. Okay, so let's come here now. All right, so CSPA, as I was saying, it can deduct the amount of time that your I-130 petition was pending from your age on the date a visa becomes available, and that will reduce your age. The new memo is talking about the fact that the date your visa became available, now USCIS is no longer going to use the date for final action chart. They are only going to use the final action chart. They are no longer going to use the dates for filing chart. Dates for filing chart. They are going to be using the final action dates chart. Okay, let's go over that again. So let me come here. Let me just use the screen that I have on here. I think that may be better for us. Okay, so in about 2015, right? Well, before that, the Department of State used to publish just one visa bulletin. And the visa bulletin is a system which is supposed to regulate how many visas are available for each filing category each month. Because there's so many people that are trying to come into the US. So the Department of State decided that, okay, we're going to do categories. Immediate relative category, there's going to be no wait time for visa availability. There's always a visa available. Spouse of a US citizen, parent of a US citizen, minor child of a US citizen, no visa wait time. But for the rest of them, F2A, F1, F2A, F2B. My screen just went off. F3, F4, all these people, every month, Department of State will say, okay, we are currently processing cases with priority dates before this cutoff point. And that's your place in queue in line. Now, USCIS, which is here in the US for processing applications or green card applications based in the US, Department of State is processing applications outside the US at US embassies. This policy update only affects cases that are being adjudicated inside the United States. Okay, now let me say, so until 2015, Department of State was only publishing one chart in the visa bulletin. And that chart was the final action dates chart. The final action dates chart just means when is a visa available for your category. Okay, so if you are the minor child of a green card holder, F2A, the date on which your family member submitted an application to USCIS, let's say August 22nd, 2025, is your priority date. If the visa bulletin on F2A shows that they're currently processing December 2025 cases, because your priority date comes before the cutoff point, your priority date is August 22nd, 2025. It comes before December 2025, which is the cutoff point. There's a visa available for your case if it's under the final dates chart. You can submit your application for a green card to be processed for your case. So until 2015, it was just one chart. Then after 2015, the Department of State started publishing two charts. Now we have the dates for filing chart, and then we have the final action dates chart. The dates for filing chart is the chart which will tell you that, oh, you can start putting together your application, you can submit your application to USCIS, but you cannot be issued with an immigrant visa or a green card because there's no visa available for you under the final action dates chart. Okay, now on May 23rd, 2018, following the publication of two charts, USCIS, what they did was they issued a policy saying that it continued to consider a visa available for CSPA calculation based on the final action dates chart. The problem with this was that Department of State was using CSPA availability. They were looking at what it meant for a visa to become available when they were reviewing the dates for filing chart. And so they realized that there was a discrepancy. That means that people who are outside the US, they have a different framework that they were using, and people who were inside the US had a different framework that they were using. Let me go here. Let's go. Okay, let's move on to the next page. Are we on there? Okay, there you go. Okay, so on February 14th, 2023, USCIS issued an updated policy guidance. And what they said was that a visa becomes available to calculate CSPA age for adjustment of status applicants. That's applicants who are inside the United States. And when USCIS determines that there were more immigrant visas available than their applicants, that means that there is a visa bulletin progression. Okay, there's a visa bulletin progression. And so when there's more immigrant visas available than applicants, USCIS will say, okay, use the dates for filing chart, because practically speaking, the dates for filing chart is always ahead. The final action dates chart is usually behind the dates for filing chart. So you'll see, I don't want to mess up what I have here. I would have shared my screen. We would have looked at a sample, let's say August 2025. If you look at the visa bulletin, I probably might share it. Usually, generally speaking, dates for filing chart is always ahead because that's the date that will notify the applicant that, oh, start putting together your documents. You can then submit to immigration. They can't issue you with your immigrant visa or a green card, but you can submit your application. When the final date chart becomes current for your priority date, then immigration can issue you with a green card. So what USCIS did on February 14, 2023 was that when USCIS determined that they should use dates for filing chart, CSPA availability, CSPA calculation, where we are looking at visa availability, USCIS will use dates for filing chart. When USCIS designated that particular month that final action dates chart should be used for adjustment of status for people who are based inside the US, then they would use final action dates chart to calculate CSPA age. And when they did that again, there was this discrepancy, right? Because Department of State was interpreting visa availability rules inconsistently with USCIS. And so the current August 2025 CSPA update, USCIS wants to align with Department of State by saying that Now we're returning to final action dates chart for purposes of calculating CSPA. What does it mean for a visa to become available? It means that we are looking at the final action dates chart. And so practically speaking, if you are calculating somebody's CSPA age, let me give a random example. Let's say the person is F2. Let's stick with F2A category, minor child of a green card holder. The child was maybe 17 years old when his mother, who's a green card holder, applied for a green card for him. He was 17 years old, and his petition, his I-130 petition, it took about, let's say 6 years. Should we say 6 years? Maybe 6 years for that petition to be approved for whatever reason. Now, when he was 17 years old, that's when mom filed a petition for him. If you're trying to calculate this guy's CSPA age in the US to see when he can apply for adjustment of status or a green card, remember that there has to be a visa available for him. The first thing you do is that you are looking at what was his age on the date a visa became first available. So if on the F2A final action dates chart, there was a visa availability for him, let's say last year, August 2020, let's say maybe let's say maybe 5 years ago, there was a visa available for him. That would be what? August 2020. What was his age at that time? Assuming he was, let's say 20 years at that time, and the petition took 6 years or 5 years to be processed. His age on the date of visa availability, let's say he was 20 years, minus the petition pending time, 6 years. So his CSPA age will be 20 minus 6 years. Just an example, that would be what? 14 years old. So his CSPA age will be 14. This is an exaggeration, but you get the point. And so what USCIS is saying is that don't use the dates for filing charts to calculate what it means for visa availability anymore. We're going to be using the final action dates chart. This obviously means that now there's going to be that consistency between Department of State and USCIS, but also it means people are likely to age out because the final action dates chart is usually practically behind the dates for filing chart. Okay, yeah, CSPA is quite boring. Let's see here. So now moving forward, you have to make sure that you are using the final action dates chart to calculate your CSPA age. The CSPA calculation for immediate relatives is very easy. If a green card holder naturalizes, and by the time they naturalize, the minor child is under 21 years old, they immediately move to immediate relative and the age is frozen. The complexity becomes when you are looking at the other factors. For example, the green card holder naturalizes and then the beneficiary ages out of that category. They age out, then you need to look at, are they going to F1? Do they want to opt out of F1 and remain in F2B? Or are they living in the ninth circuit where there's that those TOVA type of cases where the age can be frozen at a point in time when they are naturalized and all that. So those are the things we're looking at here. CSPA age, no longer for USCIS visa availability purposes. We're going to be using the final action dates chart. Simply put, no longer are we going to be looking at the date for filing chart. Okay, let's go here. Let me see if there's anything I left out. We just have a few minutes more to go. We haven't covered a lot. Oh my goodness. We haven't covered false claim to US citizenship and the other topics. We wanted to discuss alligator Alcatraz as well. And then, take some questions. Sorry. Okay, so let's just look at the timeline on CSPA. Timeline on CSPA. Let's see here. So 2001 and 2015, the final action dates chart was the only chart that they were using. 2015, Department of State implemented the two-chart system. Let me start by saying that CSPA was enacted in 2002. The number two, 2001 to 2015, final action dates chart was only chart that they were using. 2015, Department of State implemented the two-chart system. The final action dates chart, dates for filing chart. The dates for filing chart again notifies beneficiary when they can assemble and submit required documents. Final action dates chart is when you are authorized to receive a green card or immigrant visa. Then in May 2018, USCIS said, okay, they were going to consider final action dates chart. If USCIS was accepting the final action dates chart, then they would use the final action date chart for when a visa is available. If USCIS was accepting the date of filing chart that month, then visa availability meant that there was a visa available under the date of filing chart. And so this brought that inconsistency. Now USCIS is aligning with the rules of Department of State. They are saying that, you know what, this is just causing a big confusion. Sometimes this, sometimes that. This is already very complex. We are already confused. Let's go back to let's return to the final action dates chart now. Consistency across, so there's no confusion. Consistency across what it means for visa availability for CSPA purposes. I couldn't do this justice like I wanted to. We might have to do another live video just for CSPA, so I can take my time and go through every single thing, and I can show you visa bulletin. I can show you the different calculation formula that we have to, you have to use for CSPA, the different permutations. It's really, really interesting, and it's an in-depth thing we can't just run through. So I don't think this has, we've been able to do justice to it. We'll come back to it another time, hopefully soon. But if you do have any CSPA inquiry, make sure you contact us and we will be happy to assist you. Let's chat some more about what's happening. So much happening. Alligator Alcatraz, that place which is a living hell on earth, according to the people who have been there. People drinking water from sewage. There's bugs, there's heat, there's just many people crammed together, lying on the floor, no medicine. That has been shut down by a judge. She said, shut that place down because it doesn't look like the required environmental checks were done. This was all a rush. Why were you rushing? Kathleen Williams, she gave her order. She said they have to wind down the facility so it can undergo required environmental assessments. And she said that they want to restore, conserve, and put other, there's been governors, senators, political figures. They have publicly pledged to support, restore, conserve, and protect the Everglades. And so she wants to uphold the fact that the Everglades should be protected. This suit was brought by environmental groups. They argued that further construction and operations at that Florida alligator Alcatraz should be stopped because it didn't comply with federal environmental laws. They said that the project Alligator Alcatraz threatened environmentally sensitive wetlands that were home to protected plants and animals, and they would reverse billions of dollars that the US government had spent on environmental restoration. So the judge agreed with it. She said, don't bring any more. I believe we've shared the judge's order in full and the last pages of the 82-page order where she says within 60 days they should try to wind down, transfer everybody out of the facility. Don't bring any more detainees. Don't undergo any more construction. And obviously it's an injunction, right? So it's a temporary thing. Obviously the Trump DeSantis, the state of Florida, I would say it's the state of Florida. they have sued to appeal this judgment. I believe in the 11th Circuit Court of Appeals. So we wait to see how that will go. Let me see if I can get some questions here. Let's see. Dhruv 1703. Please contact us if you need help with your, your CSPA case. Love Preet 9820 Core on Instagram says, my citizen spouse applied for US visa in February 2023. Still processing 2 years later. More like 2.5 years later. That's quite strange. Shouldn't take that long. I mean, it does take time, but 2.5 years for just an I-130 for the spouse of a US citizen seems like there could be something wrong. We don't see our cases take that long, and they do take some time, but that's a lot of time. So you might want to look into that to see what's going on, see if everything is regular. Sometimes there are some delays, and sometimes you have to push them a little bit depending on what's going on. Nana Kosia Brichum says, so can you still file for citizenship after 3 years in marriage? You can, absolutely. If you're married to a US citizen, then you can. You're married to a US citizen, you've been a green card holder for at least 3 years, then you can. Oh my gosh, okay. I didn't even see this comment about you not hearing me. I'm sorry, Emmanuel Apia on LinkedIn. Let's see here. A LinkedIn user on LinkedIn said, thank you, Ikea. This is super helpful. That's wonderful. Edu Ibrahim says, good afternoon, lawyer, watching it live in Ghana. Wonderful. God bless you for your work. Thank you. Any more questions? Let me see. Selena Martin says, good afternoon, everyone. Today is a beautiful day. Indeed, it is. On TikTok, Nee says, can a person change their B1, B2 visa into student visa while in the US? Yes, they can. Absolutely. It's called a change of status. It's called a change of status. You can file it while you're here, but there are things you need to check. You kind of get an officer who's reviewing your case and say that, why did you try to file a change of status? Why didn't you apply for an F1 visa when you were coming in from your country? So there are things you'll have to be able to prove to show that there was no fraudulent intent. Like, when did you get accepted into the school? When did you even apply to the school? How long ago did you know you wanted to attend school? Things like that. So you have to be careful with that. But yes, it's done. We've done a lot of these cases with great approvals. Fear AK says, hi AK, you're doing a great job, lawyer. I've been following on WhatsApp. That's wonderful. Follow our WhatsApp channel, US Immigration by AK Poku Law. Okay, follow us and you'll get all live updates as much as possible. Let's see if we have any other questions. We probably have a lot of them. Let me see here. On Instagram, I saw a bunch of them on Instagram. So let's pick one. Guys, stick with us until the end. Somebody says, what would you say about the latest accident by an Indian truck driver? It was viral news. I haven't seen that particular news article, but I'll take a look and then we can share what we think soon. Okay. Let's see here. I'm trying to see if I can find the CSPA question that the person was asking. I cannot find it here. Okay. Posidon on Instagram says, I was wondering if I can get a U visa if someone used my identity to sign on my behalf to apply for auto loan. Possibly, if you are the victim of a qualifying crime, you need to contact us. We need to look up which state you live in and how we can classify that act if it's one of the qualifying crimes for you visa purposes, blackmail, extortion, contract. There's a lot of crimes, and we see whether we can properly frame any of the any of what happened as a crime, and then we can do the U visa certification and then U visa. So contact us for that. Okay, and then we can do that analysis for you. We will not be able to do that online here. Okay, let's see here. Okay, this person said CSPA Act for F3 category. I'm not sure what you mean by CSPA Act for F3 category, but the F3 category is the category that is meant for married children of US citizens. F3, if you are married, then CSPA cannot apply to you because you're already married. You see, if you're trying to do CSPA, then you're trying to preserve your age as a child. So if you are married, then how can this apply to you? CSPA should be for children. You're trying to make sure you maintain your status as a child. So getting married, then you're in the F3 category. And the F3 category, you cannot opt out. You gotta stay in that category. Unlike the F2B category, where you're the adult child of a adult son or daughter of a of a green card holder. I'm sorry, F2B, adult son or daughter of a green card holder. That means you're above 21 years old, and you age up, right? You turn. Let's say you are 23 years old. So let's say you were in F2A as a minor child of a lawful permanent resident. Let's say you were 18 years old. Then you age out. You turn 23. CSPA will allow you to either, instead of going to let me explain that. If you are in F2A and you are under 21 years old, let's say you are 18 years old and you become older, you will move to F2B category. Okay, you will move to F2B category because you are now above 21 years old. F2A is for under 21 son, daughter, child of a green card holder. F2A, under 21 years old, child of a green card holder, minor child. F2B, above 21 years old, son or daughter of a green card holder. So if you are in F2A and you age out, we use CSPA to see whether you can remain in the F2A category. Otherwise, if CSPA doesn't preserve your age, because sometimes even after you do the CSPA calculation, the person is still above 21. So they will fall in F2B category. Now with the F2B category, if your petitioner naturalizes and becomes a US citizen, then you have the option to either opt out. You are going into F1 instead of going into F1, which is the married son or daughter of a US citizen. You want to remain in F2B as a married son of a green card holder. The law gives you the ability to affirmatively petition USCIS or NVC to opt out of F1 if the F1 queue for the visa bulletin is longer. So you opt out and then you can remain in F2B. If you don't want to opt out, you can convert to F1. So for F3, if you are married, then you can no longer be a child for purposes of the CSPA because you are a married person. So you cannot be processed as a child. All right, guys. So it's been a pleasure hosting this live session. Let me see if there are any more questions. We have gone over our time today. Please, if you have questions you need help with, contact our office. That's how we can do legal analysis. It's very difficult to do this type of analysis on social media. It's not even ethical. And so it's best that we understand the totality of your case and we can give you proper legal advice within that context as well. Okay, guys, if you've not followed our pages across social media, make sure you do so now. Share this live video session, comment, like when you see our posts, comment, share, engage with our posts. That's how we are encouraged to do more and bring more your way. And if you need help, obviously contact AK Poku Law 802-780-0564. I think It is it should be on the screen right here, and then in our bios. Ella on YouTube says, I like your threads on Instagram. Thank you very much. We appreciate it. We appreciate your comments. Make sure you like and you comment. All the people asking questions, please contact our office and we can have time for you one-on-one. I'm sorry, and then we can assist you. All right, guys, I'll see you hopefully next week in our next live session. Make sure you stay tuned, and yeah, I wish you all the best. Take care, everyone. Have a great weekend. Bye-bye.